For preliminary examination, or at least to deal with his motions, what are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry, and
Yes.
perhaps we could look at the motion first?
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor. So I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry. I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes.
this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until
Suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained. And because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
that I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it, anything that happened. I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. No.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. You may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand. And that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor?
The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could go go south for you.
Yeah, I
understand. Not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess. All right. Court recalls case People versus Daniel McGraw. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings, you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
Yes. Go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note it. I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office. So that may be something that I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of.
I believe it's the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
All right.
I would like then to motion for a preliminary examination to get the officers in here on the record, then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter. and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Your Honor.
Yes. So preliminary examination will be set January 21st. 2025, 9 a.m. before me. That's in person.
What we just witnessed is a textbook example of how dangerous self-representation can be in criminal court, especially in a felony case. From the very beginning, the judge made one thing crystal clear. The defendant has an absolute constitutional right to represent himself, but that right comes with serious consequences. The court will not guide him, will not soften the rules, and will not rescue him from his own mistakes. This case centers on a charge of resisting and obstructing a police officer, a felony punishable by up to 2 years in jail, fines, and court costs. That's not a minor charge, and yet the defendant repeatedly approached the process as if it were a civil matter, confusing criminal discovery rules, misapplying Miranda law, and filing motions that had no legal foundation in state criminal procedure. One of the most important moments came when the defendant attempted to suppress body camera footage based on Miranda rights. Here's the critical legal issue. Miranda warnings apply to custodial interrogation, not simply being detained or recorded. The judge correctly denied the motion because the defendant failed to establish the legal elements required for suppression. This wasn't about fairness, it was about law. The discovery disputes tell an even deeper story. The defendant demanded records, depositions, medical files, and sealed evidence without first following the basic discovery process. Criminal court does not operate like federal civil litigation. There are no depositions. Medical records are protected, and the prosecution has no obligation to chase down evidence simply because a defendant demands it. Every denial we saw was rooted in procedural law, not judicial hostility. What made this hearing especially tense was the judge's growing frustration. At multiple points, the court explicitly warned the defendant that filing frivolous motions would not be tolerated. That's not intimidation, that's case management. Courts are obligated to prevent abuse of process. And when a defendant floods the docket with unsupported filings, it can seriously harm their own credibility. Perhaps the most striking moment came when the judge openly questioned whether the defendant truly understood what he was doing and even raised concerns about competency, not as an insult, but as a legal safeguard. That's how severe the disconnect had become between the defendant's intentions and the legal reality of the courtroom. Despite repeated offers of appointed counsel, the defendant continued to refuse representation. This is critical. Once a defendant knowingly waives counsel, the consequences fall squarely on them. The court fulfilled its duty by warning him over and over again. At that point, the responsibility shifts entirely to the defendant. So where does this leave the case? Procedurally, the court denied the motions, allowed a limited adjournment, and moved the case forward toward a probable cause conference and preliminary examination. Nothing was dismissed. Nothing was suppressed. The charges remain fully intact. The broader lesson here is simple but powerful. Confidence is not competence in a courtroom. Legal language without legal understanding is not strategy, it's risk. This hearing wasn't about guilt or innocence yet. It was about whether the process itself would be respected. And right now, the defendant is fighting uphill against the rules he refuses to fully accept. Now, I want to hear from you. Do you think the judge was being fair or too harsh? Should defendants ever represent themselves in felony cases? Would you have accepted the public defender if you were in this position? Drop your thoughts in the comments dot, and if you found this courtroom exchange as intense and revealing as we did, make sure to hit that like button, share this breakdown with someone who follows real courtroom drama, and subscribe to the channel so you don't miss our next jaw-dropping legal breakdown, because in this courtroom, the law doesn't bend and neither does the judge.